Welcome to The Sound of Ideas. I'm Anna Huntsman, in today for Stephanie Haney. Thanks so much for being with us. The U.S. Supreme Court wrapped its term with a series of major decisions on immigration, presidential power, and election law. Among the final rulings yesterday, the court voted against President Donald Trump to uphold the citizenship clause of the 14th Amendment, declaring anyone born within the borders of the U.S. a citizen of the country. Last week, the justices held that courts cannot review Department of Homeland Security decisions to end temporary protected status, clearing the way for the Trump administration to end legal protections for Haitians and Syrians, which includes a large Haitian community in Springfield, Ohio, that drew national attention. The court also ruled that Congress cannot prevent the president from removing members of the Federal Trade Commission, overturning a 90-year-old precedent that had preserved federal agencies' independence. President Donald Trump celebrated the decision on Truth Social, saying it greatly increases presidential power, quote, at a time when it is most needed, unquote. Two of the dissenting justices said this decision completely reshapes our government. The court also upheld a Mississippi law allowing mail-in ballots postmarked by Election Day to be counted for up to 5 days afterward. Today, we'll talk about these decisions, what they say about the direction of the High Court, and what they could mean for everyday Americans and the balance of power in Washington. Joining me in studio today is Jonathan Entin, professor in the School of Law at Case Western Reserve University. Hi, Professor Entin.
Hello.
And with us by video call is Cesar Garcia Hernandez, professor of law at The Ohio State University. Hi, Professor.
Good morning.
And Dr. Ali Massoud, assistant professor of politics at Oberlin College and Conservatory. Hi, Professor.
Good morning.
If you'd like to join the conversation, give us a call, 866-578-0903. Send us an email, soi@ideastream.org, or message us on Instagram at The Sound of Ideas. So let's just start by talking in general about what these rulings kind of mean from this term. You know, President Trump's first year back in office has been characterized by a wide, sweeping expansion of executive power. So I'll go to you first, Professor Entin. Did the end of term rulings reflect this idea of this expansion of power, or did it reject some of the efforts?
Well, at one level, the rulings were something of a mixed bag in the sense that the president lost on the citizenship case, and earlier in the term, he lost on the tariffs. But overall, the court was very sympathetic to presidential power. I think the Federal Trade Commission case that overruled that 90-year-old precedent, that is the most important case of the term, I think, in terms of what it means for the way the government will proceed from here on out. But the president was right to say that on the whole, he had a pretty good term, although he didn't win everything that he wanted.
What about you, Professor Hernandez? Were there any themes that you feel like are really connecting in this Supreme Court term?
Yeah, I think the president's authority to act unilaterally to dispense with Congress certainly received a judicial approval by and large, certainly not across the board. But to be frank, some of these losses were to be expected. I think they came in matters in which the president was really pushing the extreme edges of what was permissible and what had been the practice of executive branch agencies for going back for generations. And I think the citizenship case in particular is a loss that was entirely expected. Although the fact is, he only barely lost. The president was able to garner a substantial minority of the votes, and that in a way is a victory in and of itself.
Yeah, I want to dive deep into that as well, but first I want to bring Professor Massoud into the conversation. Which justices do you feel like had the biggest influence in this term?
Well, certainly the Chief Justice who wrote the majority opinion for all of the cases that had President Trump's name in it, Trump v. Barbara, Trump v. Cook, Trump v. Slaughter. And so you can really see the role of the Chief Justice wanting to have his influence in kind of shaping the trajectory, keeping the coalitions together. Like one thing I wanted to add is like the theme you see with the opinions of the Chief Justice is like there's the through line is that the court is saying that the president has very broad powers, lots of discretion, but that discretion is not infinite.
So let's go ahead and get into first Trump versus Barbara. So let's first back up and talk about what is this case about? Who are the parties involved? Professor Hernandez, I'll go to you for this.
Yeah, so the president was trying to reinterpret the way in which the 14th Amendment to the U.S. Constitution has been understood for well over a century. The 14th Amendment is the source of citizenship for the vast majority of U.S. citizens going back to the late 19th century. It provides a broad-based access to citizenship based on the location of birth, and was added to the U.S. Constitution in the aftermath of the Civil War. And since then, since the late 19th century, the federal courts have interpreted the language of the 14th Amendment to grant citizenship to every child born in the United States, with very narrow exceptions for children born to invading armies, children born to foreign ambassadors stationed in the United States, and to the children of Native Americans. The last group has been granted citizenship for about a century now, thanks to a law enacted by Congress. But the first two continue to this day to not receive citizenship at the moment of birth. And President Trump, on his first day back in office in 2025, issued an executive order dramatically narrowing access to citizenship based on the citizenship and immigration status of the parents of that child, incorporating into the 14th Amendment a reference to parents that does not appear in the text of the 14th Amendment. And this is the fact that the president lost was fully expected. President himself had said he expected to lose. This was a high-profile issue for him. He campaigned hard on this issue. He promised his supporters that he would do everything in his power to narrow access to citizenship. And it was so important to him that he actually attended parts of the oral argument in this case, making him the very first president in the history of the United States to attend a session of arguments before the U.S. Supreme Court. The fact that he lost was not expected, but on the constitutional issue, he actually only lost by one vote. It was a 5-4 decision when it came to whether the president's executive order violates the 14th Amendment. There was one additional vote by Justice Brett Kavanaugh that focused on the text of a law enacted by Congress, in which Justice Kavanaugh says that the president's executive order actually violates that law. But that law, like any other law enacted by Congress, can be amended. It can be repealed by the ordinary process of congressional legislation.
Yeah,
So when
can
it
you
comes
talk
to the
about what this
constitutional issues,
means? Sorry to interrupt, but I wanted to kind of break it down. So talk about what the majority found, but then that point that you were just making about the concurring opinion, can you break down really what this means? What did the court really decide here?
Yeah, so the court decided that the president's executive order clashes with the 14th Amendment. The 14th Amendment is focused on the location of a child's birth, and because of as long as somebody is born in the United States, the Supreme Court says that is the only requirement on practical terms for all but the handful of children who are born to those exceptions that I mentioned earlier. The text of the president's executive order was hoping to eliminate from birthright citizenship kids born to fathers who are not U.S. citizens or permanent residents, that's a green card holder, and mothers who are in the United States either under a temporary visa. There are about 24 of these and on the books right now in the United States, or in the United States without the federal government's permission. And the Supreme Court, the majority of the court rejected wholeheartedly that position, leaving intact the generations old legal tradition in the United States of granting broad access to birthright citizenship.
Professor Entin, what do you think happens next? Should we expect future lawsuits, laws being created? What do you think is going to happen now?
Well, there are only two ways to overturn this ruling. One would be to have a case in which the Supreme Court changed its mind and overruled yesterday's decision. The other would be a constitutional amendment. It is almost impossible to imagine a constitutional amendment getting through. In order to get a constitutional amendment passed, you need to get a 2/3 vote in both houses of Congress, and then you have to get 3/4 of the states to ratify. I don't think there's anything close to 2/3 majorities in either house of Congress. In fact, it's not even clear to me that there's a majority in either house of Congress right now. Never mind that I can't imagine that you could get 38 states to ratify such an amendment. So I think this is going to be a talking point, perhaps for a long time. But I think this essentially settles the issue, even though, as my colleague has said, people going in thought that this was going to be a lopsided majority to reject President Trump's order, and it turned out to be much narrower than people expected. So I think if it's going to change, it will be when the composition of the court changes down the road and somebody tries to bring this issue back and get the court to reconsider.
866-578-0903 is the number to call if you would like to get in on this conversation. Right now, we're talking about Trump versus Barbara, the ruling that upheld birthright citizenship in the United States. We've got a lot more to talk about, but before we do that, Professor Massoud, is there anything else you wanted to add about what the majority had to say, what the dissenting side had to say when it comes to this case?
Yeah, one of the things that struck out to me was the lengthy dissents. There were over 130 pages of dissents from the three dissenting justices, including a dissent that was over 90 pages by Justice Thomas. And the nature of those dissents are a fundamental disagreement, like on the merits. But the other thing that was interesting was Justice Kavanaugh's concurrence that was alluded to earlier. Basically, Justice Kavanaugh provides the way forward for the president to proceed moving forward. Basically, what Justice Kavanaugh is saying is that because this was done unilaterally through executive order, Congress has not weighed in. It conflicts with the statute, and so the way forward is for Congress to do something. So Congress could pass a new statute. They could overturn their existing statute. And the general sense from all of these separate opinions is that the fight is not over. As was alluded to earlier, even though the 14th Amendment is pretty clear, the historical origins are that following the Civil War, like we didn't want to deny the children of former slaves to citizenship. So the 14th Amendment is quite clear on that. But the fact that it's narrow and 6-3 officially, but 5-4 on the constitutional question suggests that any one-member change in the court could lead to this ruling being overturned.
Yeah, thank you very much for that context. So that's Justices Alito, Thomas, and Gorsuch who did dissent on that. So let's move on to the case that has had a lot of talk here in Ohio about Haitians and the Syrians with their temporary protected status, Mullen versus Doe. So Cesar, let's go back to you. What is this case about and what happened here?
Yeah, the Mullen versus Doe focuses on temporary protected status. That's a legal power that Congress enacted in 1990. Congress created it in 1990 to provide humanitarian legal protection to citizens of countries that are deemed too unsafe to return to. And since 1990, it has been used by every presidential administration, including the first Trump administration, to extend a welcoming hand to citizens of countries that are engaged suffering through some kind of turmoil. Turmoil. It might be political, it might be economic, it might be a natural disaster of some kind. And as a result, there have been for decades now people who have acquired legal permission from the federal government to live and importantly to work in the United States under temporary protected status. The Trump administration, or President Trump's first Secretary of Homeland Security during the second term, Kristi Noem, came into office, and at the time there were 17 countries whose citizens were designated as eligible for temporary protected status. Secretary Noem attempted to terminate the TPS for 13 of those countries, including Syrians and Haitians. This case was focused on the Secretary Noem's power to terminate that those TPS designations. Effectively, the argument by the challengers was that she had not followed the process laid out in the federal law enacted by Congress back in 1990. That law requires that prior to terminating, the Secretary of Homeland Security engage in consultation with appropriate government agencies outside of the Department of Homeland Security, traditionally as the Department of State. As these cases played out, it became clear that there were a few emails sent by high-level officials in the Department of Homeland Security, aides Secretary Noem, to the Department of State, none of which touched on the circumstances on the ground in Syria or Haiti, and instead were focused on just on potential foreign policy ramifications of terminating TPS. The justices actually went one step further and said, not only does it not matter what those emails said, it doesn't really even matter if there were emails that were sent or any other communications, because the courts have no role in reviewing whether the Secretary of Homeland Security followed the process set out by Congress. If Congress doesn't think that the Department of Homeland Security followed that process, they can change the law, they can withhold funding, but there's no role for the courts in overseeing a decision to end TPS. So effectively, that means that the Department of Homeland Security, the Trump administration, can move forward with its plans to end TPS, first for Syrians and Haitians, and then for citizens of the 11 other countries that it has already put on its to-do list.
And we'll talk about what this really means and kind of the next steps here, especially how it relates to the Haitian community in Ohio. But Professor Entin, did you expect this decision?
I'm not surprised about the decision, and I think that there are a couple of points to be made here. One, as Professor Garcia Hernandez was pointing out, the statute says that courts may not review the determination of the secretary with respect to TPS. And as he pointed out, the challenge actually was that the Secretary of Homeland Security had failed to follow the statutorily required procedures. Now, we have a number of other federal statutes that say that the determinations, the factual determinations by various agencies are not subject to judicial review. Courts generally have interpreted those statutes fairly narrowly, and so the challengers were basically trying to rely on that narrow approach to say, we're not trying to get the court to second guess the revocation of TPS. We're trying to get the court to say that to get to that decision, whatever it is, you have to follow a particular process. And I think the implications of the courts reading that provision broadly might carry over into other areas of law that don't affect immigration, but affect a lot of what we deal with on a day-to-day basis.
Like what?
Well, for example, veterans benefits or other kinds of benefits, SNAP or Medicaid or even Social Security benefits. Now, some of those decisions are subject to judicial review, but a lot of them aren't. And that will give greater latitude to agencies to do things that may at least be open to question. And so that might limit people's legal recourse against arbitrary government decisions.
Professor Hernandez, I'm curious what this means for other countries that have temporary protected status and kind of what happens next here.
Yeah, I think everyone who is currently a recipient of TPS should expect that the Trump administration is going to move forward with its announced plans to end TPS, and along with that means their legal permission to live in the United States and their legal permission to work in the United States. That includes citizens of Venezuela, Nicaragua, and other countries across the world. And I think this is not by any means a decision limited to the 350,000 or so Haitians, nor is it limited to the 4,000 or so Syrians. Quite the contrary, there's about 1.3 million people who currently have TPS living somewhere in the United States, many of whom have been here for decades. The longest running TPS designation is actually for citizens of El Salvador. And all of those individuals should expect that the Trump administration sooner or later will turn their attention to them.
866-578-0903 is the number to call if you have a comment or a question. You can also email soi@ideastream.org. We have a call from Todd. Hi, Todd. Welcome to the Sound of Ideas. What's your comment or question?
Okay, I don't know everybody's name.
That's okay.
But I do know Jonathan's name.
He's a regular, if you will. Yes. Go ahead.
One of your best guests, one of your better guests. But this is to the group. Is this a matter? Will this become a matter of illegal behavior by the government? Because I have this consideration for y'all to think about. There are over 1,000 children that were born in this country. Hundreds of them were born in the Springfield area to parents from Haiti. So these children are all American citizens. Now, if the State Department says all of these Haitians, Haiti is unsafe, and the State Department does say that. That's why commercial American airlines don't go there. But if the government throws these parents out and the parents take these kids, American citizens, back to Haiti, have they put American citizens in harm's way as a result of illegal behavior by the government? And or if the parents leave and say, well, our children are citizens, they're going to stay here, but now they've been abandoned. So now you have two issues here, abandonment and forcing them into a dangerous place. God forbid any of these children die over in Haiti over some dumb stuff.
That is an interesting
Could
point
you
that you
address
bring
that?
up here. Yeah. So what do you think about that, Professor Hernandez? What Todd is asking, is this a child endangerment issue either way?
Yeah, certainly. If families choose to return to Haiti, the likelihood that they will be subjected to criminal targeting or other kinds of danger is quite high. This is exactly why, as your caller points out, the U.S. government officially formally declares Haiti too unsafe to visit. I think the more realistic option, though, is that most people simply will not leave. Instead, these are individuals whose roots are firm in the United States. They run deep in the United States, and the example of children who are not only U.S. citizens but who are being raised and acculturated in the United States are a prime example. People are not just flesh and bones that can be moved around without creating emotional attachment, financial attachment, and aspirations. On the contrary, we regularly embed ourselves in community, and that community means something quite important to us. And it is very difficult to detach ourselves from that, absent the most the strongest of reasons, as all of these individuals have already experienced in their decision to leave Haiti once. And so I think the most realistic outcome of the TPS decision and the Trump administration's plans to move forward with stripping Haitians of their legal permission to live in the United States is that we will start to see an expansion in the number of people living in the United States without the government's permission. It's a delegalization campaign.
I did want to point out that there are more than 10,000 refugees living in Ohio. On July 6th, those without TPS status could no longer be able to apply to renew a driver's license, and it's also going to impact work permits that allow the refugees to seek employment. So we'll definitely be paying attention to that here at IdeaStream Public Media, and our partners across the state will continue to cover what's going to be happening because of this. But let's move on now to another case, Trump versus Slaughter. This is about presidential firing power. So let's talk about this one. We've got Professor Ali Massoud. Tell us about what this case is about and what it means.
Yeah, at the core of this case is the president wanting to remove an official at the FTC, and this kind of raises like long-standing precedent, which is Humphrey's executor. Just like a quick synopsis, Humphrey was a commissioner that President Roosevelt wanted removed, and then for political reasons. But the statute that created the Federal Trade Commission outlined the conditions under which a commissioner could be dismissed, and this was for political reasons. The court said that it had to be for cause, it had to be for those stated reasons. So now we revisit it in 2026, and what the court has done is they've overturned Humphrey's executor, and what this essentially means is for these independent agencies and commissions that have that report both to the executive and to Congress, and the argument is that the FTC is not really performing the functions of the executive branch. I think the counter argument is that they are involved in enforcement, sending cease and desist notices, making sure they're fair trade practices. But at the end of the day, what this means, what the implications are, is that the president has really broad authority in whom they want to appoint and whom they want to dismiss. Like at the heart of this is lack of permission from Congress. The president nominates, the Senate confirms, but when it comes to dismissal, what the court is basically saying is, in order for the president to pursue their priorities, they're able to dismiss individuals without cause, without the stated reasons, all right, without any, without the cause of being inefficient or some gross negligence, in order to pursue the president's priorities.
Right. That was my biggest question was, when Trump removed Slaughter from the FTC, he said her service was, quote, inconsistent with his administration's priorities. So not accusing her of inefficiency or incompetence. So do you think that's what this means going forward then, Professor Massoud, that there can be really any reasoning now to fire somebody?
Yeah, well, the court said that in order for the president to pursue their priorities, they can dismiss any individual. And what this means long term is that as we see changes in administration from one party to another, but even inter-party, when we go from one president to another, we'll see lots of changes in the nearly 24 agencies. There's going to be a lot of turnover. What's interesting is the court is making the argument that in order for these agencies to perform their functions, to pursue the president's priorities, like it has to be clear, and the mandate can't be you're creating a fourth branch, which is just this bureaucracy. But what this effectively does is it creates a lot of turnover. So every time we'll see a new administration or even a new president sworn in, even if it's the president from the party of the outgoing president, we'll see lots of turnover because that turnover is going to reflect the new president's priorities.
Professor Entin, do you have a comment about this too?
Well, I think we need to understand that the Federal Trade Commission is one of, as Professor Massoud says, one of about 24 so-called independent agencies. Most of the federal government doesn't have independent agencies. The ones that we have are important, like the Federal Communications Commission, Federal Trade Commission, Securities and Exchange Commission, et cetera. But all of the cabinet officers are in the executive branch, and the president has always been able to remove cabinet officers and other high-level executive branch officials. The idea of independent agencies has been controversial for a long time, and not simply among conservatives who have been really riding this hobby horse now for about 40 or 50 years. Even before that, there were concerns that independent agencies undermined the president's ability to do things. So what's really going on here is that the Supreme Court in the Slaughter case has said Congress may not make the judgment that certain kinds of functions or certain agencies need to be insulated from complete White House control. The court, the majority, has said the Constitution divides power among three branches, and each branch is the master of its own house. The president is the head of the executive branch, therefore the president should be able to do these things. Now, there is a lot of controversy here about the court's analysis, about the quality of the reasoning in the Humphreys Executor case, and even if you recognize that, that was a unanimous ruling with some of the most liberal and some of the most conservative justices we have ever had signing on to it. So this is a really big deal. But I think it goes beyond the top of the agency. The court didn't say anything about this, but if you look at some of the things that President Trump has said in firing lower-level federal workers, he's been saying, this is consistent with my authority as chief executive. This could raise real questions about the validity and the continuing existence of the civil service. As I said, the court hasn't said this, but a lot of the language in the majority opinion might encourage President Trump to say, I can fire pretty much anybody who works for the federal government.
okay.
Indeed, they've been making this sort of argument, and so far the courts have been willing to tolerate that.
Speaking of presidential authority and the expansion of that, let's take a call from Justin in Stowe, who's got a comment about this. Hi, welcome to the Sound of Ideas.
Hi, thanks for having me on. I've been a government history teacher for more than 20 years now, and when I teach the Constitution, I always teach that the executive branch was purposely weakened by the framers because of the fear of the royalist model, and that the legislative branch was to be the most powerful branch because it represented the people. It's seeming to me I might have to change what I'm teaching with these rulings. Is that an accurate assessment?
What do you think, Professor Enton?
Well, I think that the way we have come at the separation of powers at the federal level, we've seen two different sorts of approaches. One is that each branch is the master in its own house. That's what the majority of the Supreme Court was saying in the Slaughter case, and therefore should be able to exercise the full extent of that power without undue interference from outside. The other approach, which, by the way, is reflected in the Humphreys Executor case that the court overruled on Monday, the other approach emphasizes that the branches of the federal government are interdependent. There are some things that each branch does by itself, but most things that the government does require the cooperation of at least two of the branches. So, for example, Congress passes laws, but the president has the opportunity to veto those laws. The president gets to appoint officials, but the Senate gets to confirm. The Supreme Court and the lower federal courts decide cases according to law, but Congress decides the size and the jurisdiction of the courts, the budgets. The Senate gets to confirm judges who are nominated by the president. So you see and we can go on through a whole series of things. And what we had a
2-hour-long show, yeah.
What we are seeing, particularly with the Slaughter case, but a number of others in recent years, is that the majority of the Supreme Court is less taken with the checks and balances approach and is more focused on the distinctiveness of the branches, and particularly the distinctiveness of the executive branch.
Well, hopefully, Justin, that helped inform how you might be writing your lesson plans this summer or refreshing your lesson plans this summer. We do have a few more cases to get to, but right now we're going to take a quick break, and when we return, we'll continue talking about the Supreme Court's end-of-term rulings. This is The Sound of Ideas. I'm Anna Huntsman, in today for Stephanie Haney. We'll be right back. You're with The Sound of Ideas. I'm Anna Huntsman, in today for Stephanie Haney. Thanks so much for spending the hour with us. We're spending this hour talking about the Supreme Court's major decisions as they wrapped up the summer term yesterday. So we were just talking about, well, actually, first, let me tell you who we're talking about all of this with. We're with Jonathan Entin, professor at the School of Law at Case Western Reserve University, Cesar Garcia Hernandez, professor of law at The Ohio State University, and Ali Massoud, assistant professor of politics at Oberlin College and Conservatory. And as always, we want to hear from you as well. If you have a comment or question about any of the cases we're talking about, 866-578-0903 is the number to call, or you can email us at soi@ideastream.org. So we were just talking about a case that dealt with presidential firing power, Trump versus Slaughter, but now I want to talk about Trump versus Cook. So Ali Massoud, tell us about this case and kind of how it differs from what the court found in that previous case.
Yeah, so this involves an individual named Lisa Cook, who was appointed by President Biden to the Federal Reserve. As people may have noticed, the president has commented frequently about the Federal Reserve and the direction that he wants for the Federal Reserve to lower interest rates. And the overlap with Slaughter is similar to that. The president wants to dismiss Lisa Cook and place an individual who would advance his own priorities. Here, the court took a different track. So on a non-merits ruling, on an opinion, again, authored by the Chief Justice, the court said that this is different from the Slaughter decision. The central bank has historically been independent. It really doesn't have executive branch functions. So you cannot just dismiss an individual without cause. And so basically what the court is saying here is that this is a different situation. This does not involve like executive authority. Now the court did add this caveat that you could potentially remove Lisa Cook by demonstrating cause, and that's still being litigated. And so we've likely not seen the end of this case.
Interesting. We had a couple people write in with comments about presidential power and kind of the ability to fire people. So let's get to Stephen, who wrote in. The argument for the president's ability to fire agency heads was that Congress shouldn't be able to saddle the president with people he or she doesn't want to work with. But where are they getting the idea that those agencies are executive branch agencies? And then we have a comment also from Marvin. The president's priorities shouldn't factor into independent agencies. The reason for existing and the priorities that drive them was set out by Congress, and every president should simply realize those priorities. Any thoughts on that, Professor Entin?
Well, as I said earlier, the idea of independent agencies has been controversial for a long time. Some people feel more strongly about it than others. But if you start from the premise that all governmental authority or all federal authority is divided among three branches, executive, legislative, judicial, then the idea of an independent agency is a little bit hard to justify. Now, there are arguments that Congress, under the Constitution, has pretty broad latitude to structure the government, and so the fact that independent agencies don't fit neatly into these categories may be a feature, not a bug, but this is part of an ongoing debate that has been with us for a very long time.
Let's talk now about Watson versus the Republican National Committee. So this deals with mail-in voting, which is something that has been talked about quite a bit in Ohio, and kind of how this now interferes with, or may interfere with, Ohio's own law about when votes actually count that have been mailed in. So the court upheld a Mississippi law allowing election officials to count mail-in ballots postmarked by Election Day, but if they come in up to 5 days after. So Professor Inton, talk about how the court reached this decision.
Well, this is a case that was decided based on the wording of a federal statute that sets Election Day as a particular Tuesday in November. And the question was, what does it mean what does Election Day mean? Nobody says that people can't vote early. The question is whether all of the ballots have to be received by the close of the polls on Election Day. A fair number of states allow a grace period. Ohio was one,
Right.
which has now been taken away. Mississippi was another, but there's several dozen states allow for these ballots to come in. And the argument has been, well, if they're not there on Election Day, then they really shouldn't count. The Supreme Court said the statute that sets Election Day doesn't say that. The court left open the possibility that Congress could pass a law that required that ballots for federal offices be received by Election Day, because Congress does have some power over federal elections. But this statute doesn't really do that. Nothing in the Constitution would prevent Congress from saying, as I said, ballots for federal offices have to be in on Election Day. And it doesn't require that there be a grace period. So Ohio, for example, eliminated its grace
Right.
period. It didn't do that because the federal law specifically required that, although a number of legislators said, well, we're going to do this in anticipation of what we think the Supreme Court is going to do. That turned out to be wrong. But the other concern about the grace period is that the post office delivers most absentee ballots, and people are concerned that the post office is not efficient enough to get all the ballots in by Election Day. I think that this case is important, but I think it is more symbolic than substantive. I think if the court had gone the other way, people presumably would have adjusted the way they cast their ballots, their absentee ballots, simply by putting them in the mail earlier or taking them to the Board of Elections and dropping them off.
Right.
Inconvenient, maybe,
Yeah.
but maybe not a game changer.
Right. So it doesn't affect Ohio necessarily, but what I wanted to point out is that, this was the first election that we just had where there was no grace period, and you had people from the ACLU saying, well, this is, this can disenfranchise voters. So it's just interesting to see, compared to what the Supreme Court said. So, we'll move on now to talking about the West Virginia versus BPJ, and this is about a big talking point: transgender athletes. So, Professor Inton, back to you. What does this say, and what did how did the court get to that decision?
Okay, there actually were two cases. There was this case was combined with a case from Idaho. Both of these cases involved state laws that prohibit transgender athletes from competing in women's sports. Now, the cases had somewhat different legal theories. One of the cases said that these laws violate Title IX, which prohibits sex-based discrimination in educational activities that receive federal funds. The court unanimously rejected the Title IX challenge, saying that if you look at the way Title IX is written and some other legislation implementing Title IX that Congress has passed over the years, it's okay for states to determine sex for athletic purposes on the basis of biological sex, sex assigned at birth. Now, the other theory was that this was a sex-based discrimination that violates the Equal Protection Clause of the Constitution. That part of the case was 6-3 rejecting the challenge. The dissenters did not reject the challenge out of hand. They said, based on the record as the case had come to the court, the decision at the lower level was not yet final, and there was an opportunity for additional proceedings in the lower courts, and the dissenters said we ought to allow for those proceedings to play out. But as I said, they were outvoted, and so both of these challenges failed. Now, there is, I think, an important qualification to be made here. These are laws that prohibit transgender athletes from participating, and the challenges were brought by transgender students. But there are some other cases proceeding in the lower courts arguing that girls who participate in an interscholastic sports are having their rights violated by the presence of transgender athletes. And the court didn't address those kinds of cases, but they're coming. And if those cases win, then there will be a basis for saying nationwide transgender athletes can't participate in women's sports. The rulings yesterday simply say that states can prohibit transgender athletes from participating, but they don't have to prohibit them. So these cases coming along may raise the question across the board.
Right.
Whether you can ban transgender athletes at all.
There were a lot of major consequential decisions ruled on this term. We talked about a handful of them today, but I did want to get everyone's thoughts on which one will have the greatest practical impact. What should we expect in the future? So Cesar, I'll go to you first. Which of these do you think has the greatest practical impact?
Well, I think actually the absence of impact is the most significant story point that I'll draw out, which is the birthright citizenship lost by the president. I think this is not only a major political issue for him; it will continue to be so. But I think the fact that the Supreme Court is maintaining the 125-year legal tradition in the United States of broad access to citizenship is the most significant thing that's come out of the court over the last few weeks as the term has wrapped up.
Professor Massoud, what about for you? Is there something that's top of mind for you? What are you going to be looking for as far as what legal issue is likely to continue to come up?
Yeah, I think it's reflecting the theme of what we saw this term. Of course, elections have consequences. Not only do we elect presidents who have their priorities, but also we're seeing that when presidents come in, they also are able to set the agenda somewhat of what gets litigated and what the court rules on. Like the broader theme that I think will continue in the coming terms is about the limits and the reaches of executive authority and this through line of what role Congress plays, right? And a lot of the rulings from this term reflect that in Justice Kavanaugh's concurrence in Barbara, right? That Congress needs to weigh in, whether it's like temporary protected status or whether it's the firing of officials. It's like what role does Congress play? Like what role do these statutes play? And really what can and can't the president do?
Professor Entin, we're running out of time. As we said before, we'd love to spend 2 hours or 2 days on this, but what are you thinking here?
Two quick points. As I said earlier, I think the most impactful decision of the term was probably slaughter. It gives the president a basis for asserting very broad authority. One thing we didn't talk about today that will have continuing impact, the voting rights cases from earlier in the term that have essentially allowed for massive redistricting pretty much at the drop of a hat and that could affect the composition of Congress in the House of Representatives.
Is there anything quickly that you feel like another thing that we didn't spend time on that surprised you or isn't getting a lot of attention?
Well, I think that we haven't talked about the so-called shadow docket, the emergency docket. A lot of rulings on that on that docket have given the president authority to proceed quickly, even while in theory the cases are playing out. But the Trump administration has done quite well on the emergency docket this term.
Well, that is unfortunately all the time that we have today. I want to thank my guest, Jonathan Entin, professor in the School of Law at Case Western Reserve University. Thanks so much for being here.
Thanks for having me.
Cesar Garcia Hernandez, professor of law at The Ohio State University. Thanks so much for being here as well.
My pleasure.
And Dr. Ali Massoud, assistant professor of politics at Oberlin College and Conservatory. Thank you so much for your time today.
Yeah, my pleasure.
If you missed any part of today's show, you can hear a rebroadcast tonight at 9 on 89.7 WKSU. You can also find every episode of The Sound of Ideas wherever you get your podcasts and on the IdeaStream Public Media YouTube page. To get the last word on today's topics, send an email to soi@ideastream.org or find us on Instagram. We're at The Sound of Ideas. Tomorrow, we'll discuss the major heat wave sweeping across Northeast Ohio. Experts will share tips on how to stay safe this 4th of July weekend and the rest of the summer. I'm Anna Huntsman. Stephanie Haney will be back tomorrow. Thanks so much.